40 years ago. This is a campaign, so you can expect most anything to come out, but we can't just stand by idly and let false charges go without some answering. We've had a lot of people tell us different things about some of these stories, and we're checking them all out. One thing I can tell you is we do have some information that we're going to share with you today, and we know that you're going to share it with those folks that you're communicating with about some of these charges. I am Bill Armistead, chairman of the campaign for Judge Moore, and I want to introduce to you Philip Jauregui, who coincidentally was chairman of Judge Moore's campaign for Chief Justice back in 2000. He's an attorney, and he is representing us in this case, and I'd like now to turn this over to Mr. Jauregui, and he'll make some comments.
Thank you, Bill. Appreciate y'all being here today. This is very important. Of course, there's been some serious allegations, and we really appreciate the media and what you guys do to help get the word out and spread the truth. Just as an aside, I've known Judge Moore for 24 years. When these allegations came out within the last week, it was incredibly painful for him, for his wife, his mom, his daughter, grandchildren. In these types of cases, there's always someone who's alleging and the other person. And in those cases, when it's true, it's horrible for the person making the allegations. But when the allegations are made and it's not true, it's also horrible for the person who those allegations are directed against. Back in 2000, Judge Moore asked me to be his campaign manager, campaign chairman, and it was one of the greatest honors and remains today and always will be one of the greatest honors of my life. During that time and afterwards, he asked me to be his attorney, and I was one of the attorneys that represented him in the Ten Commandments case. And as you know, there have been some other cases over the last 20 years. And I've traveled with Judge Moore all over the state, different states across the nation. I've been with him in probably over 100 different meetings and been around probably in excess of 10,000 different ladies in Judge Moore's presence. And not once, not one time, have I ever seen him act even remotely inappropriate against any woman, toward any woman. Not when they were walking away, not when he and I were in private afterwards. That's the man that I know and that I've known for the last 24 years. Now, the allegations that have come out, I hope you understand, it takes time to work through this. We don't have a $20 million budget as a campaign. It takes time, and we want to be correct. We want to make sure that when we say something, it's proper. Okay, so we're still working through some things, but there are some things that you need to know and that we want to make you aware of. During the press conference that Ms. Nelson and Gloria Allred had on Monday, they both said that Ms. Nelson, after the allegations, had never seen nor had any contact with Judge Moore. As it turns out, in 1999, Ms. Nelson filed a divorce action against her then-husband, Mr. Harris. Guess who that case was before? It was filed in Etowah County, and the judge assigned was Roy S. Moore, Circuit Judge of Etowah County. There was contact. Judge Moore signed an order in that case as well, and we'll talk about that in a minute. We've also had a handwriting expert looking at the evidence that was submitted. You may remember on Monday, Ms. Nelson and Ms. Allred, in support, really the only piece of evidence they had in addition to the allegations was a yearbook where they claimed that it had been signed. And they said very specifically, look back at what they said. Everything on that page they said was written by Judge Moore. Now, Judge Moore not only has denied everything she said before, but now flatly denies that. And he says it's not true. We have a handwriting expert, that's looking at those. But here's the problem. A handwriting expert can't look at a copy on the internet, right? They've got to look at an original. So right now, Trent Garman, our attorney, has sent a letter, or is sending a letter, to Gloria Allred demanding that the yearbook be released. We'll send it to a neutral custodian. We'll keep chain of custody, and our professional expert will examine it, and we'll find out, is it genuine or is it a fraud? There are a couple things also that you need to know. I'm not going to go into everything that's on that paper because, again, we need to have our handwriting expert draw some conclusions. I'm not going to draw them today, and I'm not going to make any allegations that we can't support with an expert. There are a couple things that you need to look at. Look at the 1977 after Merry Christmas. Look at those two sevens. And then look below at the 77. And I want to ask you, do you think it was written by the same person? I want you to look at Old Hickory House, which they say Judge Moore wrote. Judge Moore says there's no way in the world that's his handwriting. And I want you to look at it. Look at some other writing of his and make your own determination. That's what our expert will be doing. But for now, I'm asking you all to take a look. Use your judgment. And then finally, after Judge Moore's signature, it has the initials capital D period, A period. Remember I told you about that 99 divorce action. Judge Moore looked at that DA after his signature, which they allege was because he was the district attorney. Well, it wasn't. He was the assistant district attorney. But Judge Moore says he can't ever remember ever signing his name with DA after it, but he had seen it before. You know where he had seen it? When he was on the bench, his assistant, whose initials are capital D period, A period, Delbert Adams, would stamp his signature on documents and then put capital D period, A period. That's exactly how the signature appears on the divorce decree that Judge Moore signed, dismissing the divorce action with Ms. Nelson. Knowing these things, I've got a question, Gloria Allred and Ms. Nelson. Do you still hold that everything written in that yearbook was written by Judge Moore, or was it written by somebody else? That's not an allegation, it's a question. And finally, we demand that you immediately release the yearbook to a neutral custodian so that our expert, you can send your expert as well if you'd like to, so that our expert can look at it, not a copy on the internet, the actual document, so that we can see the lettering, we can see the ink on the page, we can see the indentations, and we can see how old is that ink. Is it 40 years old, or is it a week old? Release the yearbook so that we can determine, is it genuine or is it a fraud? Thank you very much.
Mr. Jareggi, what do you say to the
I have some information I'll be happy to pass out to you guys. We have, first of all, you've probably seen a lot of this on the internet.
Please step up to the mic. Thank you.
You've probably seen a lot of this on the internet. These are copies of what was shown by Mrs. Allred. I'll just let you all pass them out if that's okay. And also what we have here is the copy of the divorce papers, not the entire thing. We show the cover page, and then what's so important is we show the final page, which has Judge Moore's signature on it with the DA.
Sir, I have two quick questions. Are there any
You see, we have the Roy Moore signature here, and the DA, which was added by his assistant, the same DA initials that are written on the yearbook.
Bill, does Judge Moore plan to testify under oath like Ms.
And I'll be glad to start these on this side.
Sir,
And since this is a legal matter, the legal expert is spoken.
Didn't Judge Moore say that he had never met her?
Thank you very much.
Why didn't you answer the original interview with Hannity, sir?
Well, I don't know what all of his concerns are, but I will say this, Wolf. Yesterday, I emailed a letter to the chairs of the United States Senate Judiciary Committee and the United States Senate Select Committee on Ethics, in which I formally requested that those committees conduct a hearing within the next 2 weeks regarding the accusations made by the 5 women who allege that they were victims of Roy Moore when they were teenagers. And my client, Beverly Young Nelson, volunteered, and she volunteered on Monday at our press conference to testify under oath at a hearing before these committees regarding what she alleges Roy Moore did to her. And we also urge the committees to subpoena Roy Moore to testify under oath about his denials of the accusations that have been made against him. So in the event that either or both committees agree to conduct our requested hearing, then we would agree to have the original yearbook examined by an independent expert or experts who would obtain exemplars of Mr. Moore's handwriting during the period in question and compare that handwriting to that which is contained in the yearbook. And so the time has come for Roy Moore to announce whether he's willing to be examined under oath concerning his conduct with regard to the 5 accusers before the Senate committees. And we're looking forward to the Senate's response and to his response to that question.
Well, if the Senate doesn't do it, are you still prepared to let outside observers, experts, look at the handwriting in that yearbook?
You know, we think that this should be done in a, in a professional setting. And this is what we have proposed, and we're not going to be distracted. Is he or is he not going to stand up, take the oath, and swear to tell the truth, the whole truth, and nothing but the truth, so help him God, before the United States Senate and before the public, not only in Alabama, but before the nation? When he is ready to do it, if he's ready to do it, if the Senate will conduct that needed hearing prior to the election, then we have made our offer to allow an independent examiner to examine this. We think that's reasonable. But until then, if he wants to evade, avoid, deny, distract, threaten to sue, try to smear, try to discredit, we're not going to allow ourselves to be distracted by all of that noise. Let him step up, let him testify, and then everyone can draw their conclusion about who's telling the truth. Why will he not answer that question? Our client's willing to testify under oath. Why doesn't he indicate that he's willing to do that and do that now, not after the election?